The Honorable Harvey L. J., Chief Judge, presiding. All persons having business before this court draw near, give attention, you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning. As you just heard, I'm Harvey J. I have the privilege and honor to be the Chief Judge of this court. I am joined by two wonderful colleagues, my longtime colleague, starting in Tallahassee, Judge Makar, who came with me over here to Daytona on the 5th, and then Judge Kilbane to my left, a longtime trial lawyer, trial judge, so it's an honor to serve with the both of them today. We just have one case, as my former clerk used to say, one case on the dance card today for OA, and that is Yelvington versus Yelvington, case number 242189. That case has been consolidated. This case has been consolidated with case number 250048. A couple things I'd like to cover with all of you. To the extent you have electronic devices, if you would please make sure those are on the silence mode. There's nothing worse than in a hearing or an oral argument to have something go off. It's disruptive. It's disruptive to the court as well as to the advocates. So thank you for being mindful of that. Second thing is we're here for a reason. And we would ask if we have questions that you be responsive to those questions. If you are not, then why are you here? And as you know, we have the benefit of your very good briefing in this case, but there's a reason for oral argument, which is the give and take on some of these questions the panel may have. Please don't mistake us intervening as being rude. In any way, that is not our intent, but we do have questions we need to ask about, so thank you for being mindful of that. The last thing, and this is a little bit unique, we have a cross appeal, a significant cross appeal in this case, and how best to divvy up the time. I was talking briefly to my colleagues before we started, and they thought best, as do I, to ask the advocates how to break up the time. I also don't have a problem, nor does the panel, in giving you 25 minutes per side, being the only case we have to deal with today. So on behalf of the appellant cross appellee, what say you as far as the breakdown?
Your Honors, I think my client's appeal is a much more narrow and limited issue, and I had gone into this thinking 20 minutes, and I had expected to spend approximately half addressing my client's appeal and half addressing the cross appeal, and I'm fine with that.
And is it your thought, and a little bit out of sequence, to do both with your first presentation, or you understand what I'm saying?
And without direction, I was anticipating that I was going to do that, and I was going to spend approximately 10 minutes addressing the initial appeal, and then 8 minutes addressing the cross appeal, and then reserve 2 minutes for my rebuttal on the initial appeal. But I'm more than happy to adjust and do 10 minutes on this appeal and 15 minutes on the consolidated appeal.
Well, thank you. That's very helpful. What says the appellee cross appellant?
Thank you, Your Honor. I've actually anticipated about the same, splitting my time evenly between the two. I think probably the most efficient presentation is just to address them all at once. That way we can address all the panel's questions all at once. We don't have to save things that might come up.
I think that's certainly in accord with what I would be fine with. Judge Makar, Judge Kilbane, you're fine with that?
We're going to divide some time.
Well, and as far as the ending event, the rebuttal, I guess both of you would be entitled to a rebuttal. So if you want to, maybe 20 minutes dealing with 10 and 10 and 10 and 10, and then 5 for any rebuttal. It's just how best to see who goes last.
And Your Honor, just to clarify, the 5-minute rebuttal, would that include rebuttal of top topics addressed in their appeal or just the topics addressed in?
I have no problem with that. I think we can keep them straight. So yes, I think that would be fair game. In my former life, I was a trial lawyer, and you got to be careful about rebuttals. But I don't think that's a problem for this panel. So yes, the long answer to that question is yes. You would be able to handle both in the 5 minutes. So it will be 20 and 20, and then 5 and 5. Does that work for both sides?
Yes, sir.
Okay. That will be the plan. So on behalf of the appellant, cross appellee, are we ready to proceed?
Yes, sir.
May it please the court.
Yes, sir.
Tim Sobchak representing the appellant cross appellee Darlene Yelvington, which I may refer to as Miss Yelvington if I slip up sometimes. The appellant seeks the reversal of paragraph 2C of what we call the distribution order. This paragraph addresses the distribution of Yelvington Jet Aviation, what we call YJA. Here we believe the trial court committed a reversible error by giving a controlling interest, 51% of YJA, to the appellee, Mr. Yelvington. And so here the trust provide the assets must be distributed 50-50. That's not in dispute. And it's our position, what that means is that you essentially take the asset and split it 50-50. It could be cash, it could be interest in a corporation, or alternatively, as was done in this very order, you could distribute the entirety of the asset to one individual, but then value that asset.
Counsel, what do you do with section 10.4 of the trust that talks about the splitting it depending on the asset? And I don't see anything in that language, but maybe I'm missing it, that says 50-50 as to the breakdown between the assets, as long as the overall was 50-50. And so what about that language would necessitate 50-50?
Yeah, you're right that it doesn't say split each asset 50-50, and I think it's correct not to say that because there is personal property involved here. You obviously can't split that 50-50. What I think 10.4 is doing is just acknowledging that the trustee or the trial court, sitting in the trustee's capacity, so to speak here, has the authority to satisfy the gift either through cash or in kind, meaning one of the pieces of property, but the ultimate end goal is that it has to be 50-50. But so where the problem comes in distributing a controlling interest is that I would say it's discretion too far because it is an unnecessary exercise in the distribution of 50-50. You don't need to make a determination as to who should get this controlling interest because no matter what you do, you're going outside the bounds of the mandate of the trust, which is just to get the parties half of the trust assets.
Back to 10.4, at the end of 10.4, it says distributions in kind may be made of entire properties or undivided shares. Doesn't that cut against what you just said?
I think I made this point in the brief that I would argue that supports my client's position because it's anticipating giving the entirety of an asset to one individual. In this circumstance, the entirety of YJA to Mr. Yelvington and then valuing it and making sure that amount of cash is distributed on the other side of the ledger. Because this is saying in kind may be made of entire properties or undivided shares. And I think the point that I'm making that it is a discretion too far is seen pretty quickly. The rabbit hole gets deep very fast because...
You would agree that there's discretion here?
Absolutely. There has to be some discretion.
It has to be.
Yeah, of course. But where does that line stop is the problem here. And in this circumstance, during the hearing, the trial court openly struggled with that. How do I give this individual 51% versus this individual? We never heard at any point what is the articulated standard for how I'm making this determination as to who gets the controlling interest. That was never argued or stated by the trial court, and it's not something stated in the trust, and it's not something stated in Florida law.
If it is bathed in discretion, would not the standard be competent substantial evidence in evaluating that?
Yes, I think generally speaking, if that is the review, exercise of discretion should be based on competent and substantial evidence. I agree with that, which then begs the question, what was the competent and substantial evidence to support the trial court's determination of giving 51%? And that's where we have an entire lack of competent and substantial evidence.
As I read the record, and I believe it was part of the argument below, it talks in terms of wanting to avoid a fight between the two. Isn't that a feature of this, of avoiding a continued fight over control?
I think that is something that the trial court discussed, but it's not something that's stated in the trust, that it's part of the trial court's discretion when making that determination.
Wasn't that advanced by your client below? As I read the record, I thought that was a feature.
I think both parties welcome the idea of separating, but that's not what happened, because giving 51% keeps them together and actually keeps them in a more adversarial position. And that's why below, I believe my client argued, just give the entirety to one or the other.
Well, wouldn't 50-50, I mean, that would necessitate constant struggles, would it not?
It might. 50-50 might, but 100 and 0 and then valuing it would not, and the trial court had that discretion to choose. Now,
So just making sure I understand, it was advanced by your client, as well as the other side, that it was within the court's discretion to avoid a fight between the two parties in the distribution of the assets.
yes, I believe it was, and I think that arguably that's also included in 1010 of the trust. And this is the other point that we made on appeal, is that if you read 1010 in the trust, it actually discusses management, and it discusses the concept of, if the trustee believes that management can't be done properly, it should, and I believe it says the grantor expressly desires that the trustee sell it. And so if we're looking for the settlor's intent on what to do with these assets, this is where we need to look. And nothing in that section would support giving 51% for the purpose of avoiding confrontation. And that section is interesting because at the very beginning, it acknowledges that much of the assets are close corporations. And then it goes on to say the trustee has sole discretion in deciding to keep the asset or to sell the asset. And that's critical for the points that I made, second and third points in the appeal, when we get to the consideration of parole evidence and determining the intent of the settlor. The intent of the settlor is very clearly stated in 1010, that the trustee has the sole discretion to sell the asset. What happened at the hearing was that the trial court considered the settlor's intent, very expressly stated this, that he believed the settlor's intent was to further a legacy. But that is a bridge too far, because if the trust document is unambiguous as to the settlor's intent, you don't go outside that trust document.
And that is the black letter law. But what do you do with the court's comment, and I know much has been made of it, keeps it in the business if we're not going to sell that business? Doesn't that sort of dissipate what you're saying the court's intent was, or trying to attribute intent to Conrad? Doesn't that wipe away what you're saying, that the court is saying this business may be sold, which would be in accord with 1010, would it not?
I frankly do not understand that argument that was made by Appelli on that point, because it seemed extremely clear to me that the trial court said that he was basing his determination on the idea of this business not being sold. And he quoted Gary Yelvington, Appelli's position that he would not sell the entity, which was not evidence because Mr. Yelvington was not sworn and stating under oath. And he said that is the consideration that I am using to determine to give the 51%. So he went outside of the trust document, but also relied on what was not evidence. which was essentially two things: the argument of counsel, which cannot be evidence, and the unsworn statements from Mr. Yelvington at counsel's table.
So, but back to my question, keeps it in the business if we're not going to sell the business. Isn't that ambiguous enough to bathe it in the discretion we talked about earlier, or not?
I don't think so. And I think at the very end, there's an exchange between the trial court and one of the attorneys about drafting the order. And the trial court literally says, as to my considerations, leave those on the record so that the Fifth District Court of Appeal knows why I did that. So I think it's extremely clear on the record. He was making the decision based on Conrad Yelvington's intent, the settlor's intent, to maintain the business in some sort of family lineage.
Counsel, if I could ask you, in your initial brief, you asked that the matter be sent back to the trial court to have an even distribution. In other words, apparently take that one share and transfer it over, make it 50-50 versus 51-49, correct?
Yes.
Okay, so wouldn't that entail a little bit more than just that simple transfer of one share? Wouldn't it have to be a total reassessment of the overall distribution of everything in the trusts?
It actually wouldn't, given the posture of the case. And this is a very good question, because there's never been a valuation of YJA. There's a record citation to 3617, which is a single analysis by the appellee. That is not an agreement to valuation. There never has been. And as it stands right now, there's millions of dollars in an account that has yet to be distributed to balance out the distribution. The trial court, I don't believe, is doing that, and because he doesn't believe he has jurisdiction based on this appeal. So it really wouldn't be a large exercise to then value the entity, or in that case, you wouldn't need to value the entity because it'd be 50-50.
The trial judge's order was entered almost 2 years ago. What's transpired with the overall distribution? Has things been locked in place?
They've essentially been locked in place.
The business has continued.
The business has been continued, solely run by Mr. Yelvington, to the exclusion of Ms. Yelvington.
If there had been any disputes that arose between the majority shareholder of 51 and minority with 49, they would have been resolved in some way during the last 2 years?
There's active litigation.
Okay, so there's other cases out there?
Yes, there's records request litigation in between the minority and majority shareholder. And the trust is essentially cash at this point. And it's maintained in an account waiting for adjustment. There's never been a final ledger, a calculation of this is what everybody has received. Now, how do we true it up based on the cash at the end of the day?
Has there been any mediation at any point?
There was mediation prior to my involvement. I wasn't counsel, but this was, my understanding, there was mediation earlier in the trust dispute. Given the time frame, I'd welcome any other questions on this issue, or I will move to the cross appeal.
Counsel, just one quick question. If there's never been a valuation of the entity, and there's obviously other assets that were in the trust for distribution, there's been different monetary allocations to each. What is the evidence that is in the record here that this wasn't equal? That this isn't a 50-50 distribution?
Well, I think I'd have to follow up and ask if you're saying based off of the July 2nd order. It's certainly not a 50-50 distribution, because then you still have the November order. And also, just if you look at the plain statements in the July order, if you look at right above that is McNabb Road, which was an entity that was valued at $1.7 million or some amount. That's given to Mr. Yelvington. That still needs to be calculated and added up on the other side of the ledger. That hasn't happened. At no point have the parties agreed on the total tabulation. In fact, this point is actually made in appellee's brief. They make this point that the trial court never went through that exercise. We agree. That hasn't been done yet, but that needs to be done.
Thank you.
Yep. So with that, I'll move over to the cross appeal. And given the time, I'm going to try to jump around and tackle some some what I think are more important points. First, I'll start with Malibu, and this is touching on what I just followed up with Your Honor. In the Malibu situation, we had an agreement that there was a 1.675 value for this property. That happened in a January 2024 hearing where Mr. Tolan, the appraiser, testified. What I think is lost on the cross appellant is that at that hearing, the valuation was agreed to 1.675, but it was subject to repairs and remediations. Everybody said this property needs to be fixed, but we don't know how much it's going to cost. Mr. Tolan said that. He even estimated the repairs to be $500,000. That's why the trial court literally said, I'm short on information, and said, Mr. Tolan's not an expert. So at the next hearing, the October 18th hearing, the idea was to present the evidence of what it takes to reach that 1.675 value. What is the repair and remediation? And this is important because what's going to happen is that 1.675 is going to be written in Ms. Yelvington's side of the ledger. That's what she's going to be receiving when she gets Malibu Court. But she's not really receiving that unless you calculate what it takes to repair and remediate the property and therefore reach the 1.675 value. That's why the October 18th hearing is not limited in any way to the particular repairs that may or may not be raised in Mr. Tolan's appraisal, because you have to consider everything. And the trial court was very clear in the lead up to that October 18th hearing and in the beginning. The trial court said, I remember telling the litigants, I'm going to give them time to show the evidence for what it takes to repair that. And so you then see 199 pages of pictures and documents, mold reports, invoices, contracts to show what that repair was.
Just so we're clear, as far as the standard of review on this issue, as I understand it, I'm quoting from Swartz, which is a third DCA case, and 24. Trial court's findings following a non-jury trial are clothed in a presumption of correctness and will not be disturbed unless totally unsupported by competent substantial evidence. Is that your understanding of our standard here as to the findings of this trial court in this non-jury setting?
Yes, sir. That is my understanding.
It's a pretty high bar, is it not?
It is a high bar, and particularly
totally unsupported. So if there is some support, and you just verbalize what you believe to be support for the finding, that would be enough for us to say the court got it right.
Correct, and it's maybe more critical in this circumstance because the cross appellant didn't present any evidence in response to this other than admitting the entire transcript from the January 2024 hearing. That was the only evidence that was presented before the trial court to sort of further their position that these repairs and remediations weren't necessary or weren't valid in any way. I'd like to quickly move over to what's called One Beach, which is another property. There's this discussion about lost profits, and I think what's lost, perhaps in the briefing, but perhaps not, it's not traditional lost profits because the testimony and the evidence that was presented, Defendant's Exhibit 1, is a lengthy document illustrating the exact fuel that was taken out of these pumps during the time within which they should have been in the possession of Ms. Yelvington. There's no need to go compare to another business because the exact documents showing what went out of the pumps and went to Mr. Yelvington during this time, we have those records, and that was presented to the court.
Is that, though, the same as profit and loss?
It's not, but where I was going next is Mr. Collins then testified to the profit margin that would be applicable to those gallons. Mr. Collins had 15 years experience operating in these locations running FBOs. That was the evidence before the court, and I think that more than meets that bar of would a reasonable person think this is speculation. I don't think that that's the case.
Counsel, one thing I'm struggling with is the trial court's order is fairly short and doesn't really get into much detail about explaining how this is a true 50-50 or approximately 50-50 split of the overall assets. I don't see that the trial judge really did that. As a consequence, we have some of these issues where it's not clear, like, okay, how much was that additional share of control valued? I mean, there seems to be the sense that the trial judge gave additional monies to Ms. Yelvington because Mr. Yelvington got control. So I'm struggling from an appellate review perspective to understand how we can ensure that the trust documents were complied with and that there was, in fact, an even split here overall.
And I think the struggle is that because the task isn't done, the cash is still there, which was intended by these parties from the beginning of the trust litigation to be that last point where they then true up the total amounts. If you go back to the July order, in the record, there's interim distributions made. There's personal property, vehicles, and things like that years ago. And a lot of that went to Ms. Yelvington. A lot of that went to Mr. Yelvington. When they did that, they weren't attempting to give that 50-50. The idea was, we're going to give that to you now, but we're going to keep track of the value. And then when we get to that last moment, we're going to draw the little ledger and we're going to figure out where everybody's at. So I understand Your Honor's question, but I don't think the court was even attempting to say that we're done with this now, we're at 50-50. There still needs to be more effort to determine. If you look at the July order, just based on the July order, it's clear Mr. Yelvington has received a lot more, because in that very order, it shows all of McNabb Road worth $1.7 million going to Mr. Yelvington. Everything else is basically split 50-50. That order shows 51% of YJA. So if you just were to take that order, you'd say, well, Mr. Yelvington is getting a lot more. We've got to do some more balancing here. So I guess in short, it is yet to be done, is the answer. So with that, I will reserve what I have left.
Thank you.
Good morning. May it please the court. My name is Clay Resch. I'm here on behalf of the appellee cross appellant, Mr. Yelvington. I'd like to start, Your Honors, with the actual language of the trust document. What it says is that the trustee shall distribute all of the then remaining principal of the trust to the following shares indicated. And then it goes on to say 1 share to the trustee of a trust for Mr. Yelvington, 1 share to the trustee of a trust for Mrs. Yelvington. So the trust document, in my view, is very clear. What's being divided here is not each individual asset. Each individual asset does not need to be 50-50. What needs to be 50-50 are the values of the shares that are going to each side. So from the language of the trust document itself, it's very clear that the trial court had the discretion to award all or less than all of an asset to one side or the other and balance that out with either another asset or an award of cash. I think that's very clear from the trust document itself. In fact, Your Honors, that was the reading of that particular trust provision by both sides of this case up until this appeal was filed.
And just so I'm clear, you're talking about section 10.4, among others, the trust document?
Yes, Your Honors. It's sections 4.3, 10.4, and then we'll eventually get to 10.10.
So, and if you could elucidate that a little further. So you're saying the position of both sides was what you just said, the position of the appellee in the main appeal was, meaning that the court could differentiate assets less than 50-50 just to make the total shares 50-50.
Yes, Your Honor. If you look at the comments that were made during the hearing on Mr. Yelvington's motion for summary judgment, her counsel, Mrs. Yelvington's counsel, argued for that approach, saying that the assets get split at the end. If there's a difference in value, that's made up in cash.
So was there an invitation of any purported error here?
I'm sorry, Your Honor?
Was there an invitation of error from Ms. Yelvington's side on that point? I mean, they're claiming that was error now, and you're saying that was a position they took below.
Well, we don't see it as an error from the trial court making the distribution.
They claim
of
it
YJA's is, but yes, they claim it is. We believe that the record clearly supports they had the same reading of the trust until the trial court made its decision. So I don't know if I'd call it invitation to error because the trial court ruled correctly on this particular issue.
What would you call it, waiver?
A waiver, an estoppel, it's just very clear to me, Your Honors, in the record that this is an argument that Mrs. Yelvington believes she can make on appeal, but it's only being made because the trial court ended up with the distribution of Yelvington Jet Aviation that she disagreed with.
Was the argument also made below, and I believe counsel, to his credit, conceded this, that in fact both sides appreciated that the differentiation of these assets could be made in a way that avoided acrimony between the parties? I mean, it sounds like both sides appreciated that could have efficacy for this distribution. Was that the case?
Yes, Your Honor. I mean, I think that was something that the trial court did have in mind throughout the proceedings.
And it was encouraged by both sides to do that very thing.
Yes, Your Honor. I believe the comments that were made was essentially it would be best if these two sides were effectively divorced from each other so that they could just have a whole clean split. And very clearly, Your Honor, you can't do that if there's a 50-50 division of a company where you have the two shareholders now who are essentially going to be at an impasse.
And doesn't, and maybe I'm missing something, but doesn't 50-50 make it worse? I mean, isn't that the worst case scenario? If it was 50-50, wouldn't that be a fight over everything, or
Yes,
not?
It would. It's creating a situation where impasse is going to arise. The company won't be able to be managed properly, and you're going to end up back in a situation where most likely you have a lawsuit for judicial dissolution of the company. So dividing it 50-50 certainly would exacerbate that situation, and that was a goal that all parties wanted to avoid.
Counsel, on your issue 4, on your cross appeal, it talks about the, I guess, YJA issue of valuation. Could you focus on that a minute? What I'm hearing from your brief, or discerning from your brief, is that your concern on appeal is that the trial judge gave the additional share, 51%, in the operations of the corporation to your client, and that Ms. Yelvington got something in response, or as a benefit for that, to offset that, and that you want us to reverse it and go back and have the trial judge explicitly say what was the value of what she received, because you think it was too much?
That's one of the issues, but yes,
maybe I'm not saying it very eloquently, but is that the gist of what you're saying?
That is the gist of one of our arguments.
So you want us
Your
to send
Honor.
it back, have the trial judge take testimony and evidence to find out how much that additional control, that value of that one share of stock that gave 51% versus 50%, monetize it in some way. Get experts come in and they'll testify about how much that's worth.
Yes, that was the procedure and process that really should have been done at the October hearing.
Mary, you're rolling the dice a little bit, aren't you? Because, I mean, the experts could say it's worth a whole lot, and she didn't get enough. And maybe she didn't get enough value because of that. Aren't you kind of rolling the dice? Because it could go either way.
Potentially, Your Honor, but the way that we look at it with the other awards that the trial judge made, nearly $2 million to Mrs. Yelvington, we don't believe, based on the valuation of YJA, what we think it's worth, that the 1% controlling interest is going to hit that amount. But you're right, it is a gamble. The trial court could come back in and say it's $2 million or $5 million if there's expert testimony to support it.
Did you preserve the issue below? I'm sorry to interrupt, but did you preserve the issue below and say, Your Honor, you need to make this determination at this point. You need to make some valuation of what that one share of stock is worth?
Well, Your Honor, that was the purpose and point of the October hearing. Now, Mrs. Yelvington never presented any evidence as to the value of what that one share was worth. So there's no basis for the trial court to award her additional funds.
But you put in evidence.
I'm sorry?
You put in evidence on behalf of your client or whoever.
We did not put in any expert testimony or expert evidence as to the value of that one share, Your Honor. No, because there was no claim by Mrs. Yelvington as to what that value should be. There was nothing for us to contest it. And I think the trial court recognized that, making a comment during the October hearing that there was no expert
But you're now
testimony.
claiming that it was an error. I guess that maybe I'm not understanding. it seems to me if you're arguing now that, oh, the trial judge should have made some determination about what that controlling share's value was, that one share tipped it over into controlling. But you didn't put any evidence in on that issue below, but now you want to have another try at it.
That's correct, Your Honor. We did not put any evidence as to the value of that one share below. What the trial court actually did is it awarded Mrs. Yelvington damages for claims on the counterclaim that she had filed. And that is what we were asserting, essentially was the trial judge making up the value of that one share. Because those claims that she had pressed in her counterclaim had already been dealt with on summary judgment. The court had found that there was no evidence on those. They were re-raised in the October hearing, and we believe that the trial court, in looking at the prior distributions giving Mr. Yelvington that extra 1% share, did award Mrs. Yelvington all of those claims, gave her,
But that argument, counsel, is of no moment. Procedurally, an interlocutory summary judgment, and that was an interlocutory summary judgment, is subsumed within the final judgment, is it not?
It is, Your Honor, but there's no basis for the trial judge to go back and reconsider or reverse his prior ruling as to that particular issue, whether or not there was any evidence to support these claims that Mrs. Yelvington was making against Mr. Yelvington.
And back to Judge Makar's point, we again know this court's ruling is clothed with a presumption of correctness. And we know unless there is a total failure to support the trial court's ruling by competent substantial evidence that we are duty-bound to affirm it. Is it not unfair to the trial court to send some back that was never asked of the trial court before? I'm just trying to reconcile that in line with what Judge Makar just asked.
No, I don't believe so, Your Honor, because there was no basis for the trial court to do what it did with respect to the valuation of that one share of Yelvington Jet Aviation.
But you've also said the following issue, you've said, let's send it back because it's not clear that it's 50-50. Right? And that's
yes.
your issue number?
That the court's order lacked the required specificity.
Whether the order awards Darlene more than half of the trust assets. That's your issue number 4.
Yes, Your Honor. So at this point in time, where we stand procedurally, below, when this appeal is over, if everything stands, then all that's left for the trial court to do is divide the remaining cash in the trust and give it each to, half of it goes to Mr. Yelvington, half of it goes to Mrs. Yelvington. The issue there is because the trial court has already decided that Mrs. Yelvington gets nearly $2 million of the trust cash up front. That's going to result in an unequal split. It's not going to be 50-50.
Well, what if we disagree with you on the first few issues in your cross appeal and that our concern is more about the overall evaluation versus the homes that were improved and so forth?
If the concern is about the overall valuation,
Yeah, and the controlling share.
at that point in time, Your Honor, if we're sending it back to reconsider just the value of that controlling share, I think that's something that can be done without disturbing the sort of current distribution plan. If we're sending it back for the trial court to reevaluate, who gets the majority share or majority control of Yelvington Jet Aviation, then I think that upends the entire thing, and we have to start from the beginning as to who should get what particular asset out of the trust.
Just seems like a bowl of spaghetti. If we send it back, it's going to be lots of litigation over the same things that you've already had, and maybe already had a chance to litigate but didn't.
I have no doubt, Your Honor, based on my involvement in this case, that when it gets sent back, there will be additional litigation, there'll be additional motions. As counsel indicated, there's other litigation, between these two parties. Unfortunately, that's the situation that we're in. And
but I'm hearing, as we sit here today, everything's been everything, personal property, so that's all been evaluated and distributed years ago. And there's a fund of money sitting there waiting to be distributed once this appeal is resolved.
Correct.
And the only corporate interest involved is the YJA.
JA, yes, Your Honor.
That's the only corporate entity, the only business interest that's at stake in this case today?
That's correct. I don't think there's
The properties
really-
and your claim that she got too much money for those, but the core corporate interest is the company.
Yes, that is the overriding, I guess, corporate problem, corporate issue before the court is whether or not that issue, that distribution 5149 was proper, and then if so, what amount should Mrs. Yelvington be compensated for? Because again, she presented no evidence as to the value of her 49.
Florida statutes allow a minority shareholder to be bought out. Are you familiar with those provisions?
So in the judicial dissolution statute, if you file a dissolution lawsuit, the defendant has, it's either 60 or 90 days to elect a buyout. I'm not aware of any other provision in the statute that would allow or where a majority shareholder could force out a minority shareholder.
But Ms. Yelvington could pursue that, could have, I suppose, from day one after this judgment and say, well, I'm a minority shareholder now. I'm contested on appeal, but if I want to drop that issue, I can just get my value for the 49% through the statute mechanism.
No, I don't believe that statute's available to her because the judicial dissolution statute, in order to file that case, you have to show any number of things. The most classic one is a deadlock in the management of the company's affairs, and the either directors or shareholders at a higher level are unable to break that deadlock. You're not going to have a deadlock situation in this case because Mr. Yelvington is the manager and he's also the majority shareholder based on the trial court's order. So, the other provisions of the judicial dissolution statute, I believe dissolution's allowed, for example, if the corporation's being used to perpetuate a fraud or some unlawful activity.
And those allegations were resolved by the trial judge in favor of your client.
Yes, the claim that Mr. Yelvington breached his fiduciary duties to Mrs. Yelvington, the trial court granted summary judgment in Mr. Yelvington's
And that's not
favor.
an issue in this appeal.
That isn't,
All right.
well, it's not an issue
Correctly.
that's being appealed. It's an issue that impacts this appeal because those claims were re-raised, and that was the basis for the trial court's decision that Mrs. Yelvington should receive, essentially $1.9 million in cash to equal up the distributions.
But there's not another appeal, is there? I thought you said.
No, there's not. So I'm sorry if that was unclear. No, that issue is not an issue being appealed. The order on the summary judgment is not being appealed, but it does impact the issues that we're talking about here today in this appeal.
Okay.
So let me give you an example, Your Honor. So the trial court awarded Mrs. Yelvington money for Mr. Yelvington's decision to use trust funds to repair 2 airplanes, a Lear 45 and a Gulfstream. So he used trust funds, repaired those airplanes, sold the airplanes, the trust funds came back and were deposited in a trust bank account. On summary judgment, the trial court looked at that and said, there's no issue here. There's no breach of fiduciary duty. However, when we get to the October hearing, which was supposed to be about reimbursements for the maintenance and upkeep of trust assets, the trial court awarded Mrs. Yelvington effectively damages because Mr. Yelvington used trust money to repair those 2 airplanes, sold them, and then deposited the trust money back into the trust. So that is where the summary judgment order impacts these proceedings.
When you say the trial court's order lacks specificity, you want us to send it back, what do you expect the trial court to do at that point if we send it back?
Would expect the trial court to, unfortunately, have to reconvene a hearing, would have to take evidence as to if Mrs. Yelvington is going to be allowed to reassert the claims that were decided on summary judgment. We're going to have to address those through legal argument, potentially evidence at a trial if the court really is walking back its earlier summary judgment ruling. Once that is done, what we're going to have to do is essentially make sure that the distributions are 50-50. What that involves is essentially the 2 ledgers that my colleague referenced. We'll have to figure out what assets are distributed to Mr. Yelvington, what assets are distributed to Mrs. Yelvington, the value of those 2, and then you even it up with cash.
Doesn't that unravel the sweater?
I'm sorry, Your Honor?
Doesn't that unravel everything? Couldn't that potentially cause everything to unravel?
Yes, it could, Your Honor.
It almost could be a do-over, could it not?
If we're going to go back and have to readjust the distributions of the property, the corporate entities, then yes, we're going to have a
And I would just
do-over on the
ask
rest of it.
you, and I know you're a very fine lawyer, you're both sides are well represented. Do you really want us to do that? I mean, in a situation where everything de novo potentially changes, or not?
Yes, Your Honor. For these particular issues, yes, that is a possibility that you know my client is aware of, and we know that it's something that the court could do. But when we're looking at what we do still have in dispute, and perhaps I was too broad when I was describing this earlier, there have been a number of interim distributions that were done by agreement. So it's not a situation where automobiles that went to Mrs. Yelvington or jewelry that went to Mr. Yelvington are going to have to be reconsidered, other than just what their value was, so that we're sure we have 50-50 on the two shares. So we're not going to have to go back and decide what each piece of property is going to go to which particular share. What we would be going back on is, depending on this court's ruling, potentially Yelvington Jet Aviation, Yelvington Aviation Management, McNabb Road, and then the cash award that the trial court made in its October, or I guess it's the November order arising from the October hearing.
Well, and counsel, you just referenced 3 entities, which was going to be my question. Have any of those entities, not just YJA, but the management entity, or I know there was some lost profits issues with the Knapp Road, but there were never valuations of the management, were there, of that entity? I know that Mr. Yelvington already owned a certain percentage, 32% or something like that, coming into this litigation, but was there a business valuation done on that?
There weren't business valuations done, there were agreed valuations. So for example, I believe the property you were referencing, the Fuel Farm One Beach, was an agreed valuation of $730,000. The interest in McNabb Road, there was a valuation that was set and agreed to. So, you know, in terms of the value of you know, some of these assets, just sort of the wholesale value, then yes, there are values that have been set.
Okay, and was a value set for the aviation management entity?
For Yelvington Jet Aviation, it was, Your Honor, it was...
I thought there were 2 different entities, and that was part of the basis for the courts wanting to keep them together with Mr. Yelvington.
There are. So there's Yelvington Aviation Management and Yelvington Jet Aviation.
Right.
You're
Jet
asking
Aviation is the one that was split 51-49.
Yes, Your Honor.
And the management entity is the one that Mr. Yelvington initially was already a 32% owner or something of that nature coming in. And so that was sort of that's what it feels like led the court to think, okay, I'm going to keep these together, separate them in business, that sort of thing based on the record. So was there ever an agreed or other valuation of the management entity at any point?
I believe there was, Your Honor, but I do not recall what it was off the top of my head. And I apologize for that.
I'm just curious because it feels like if the request is to send it back, this was all on the table initially. And none of these businesses were not valued. And because that's the issue, how are you ever going to true it up or how do we know that there was error? That's the burden here, is how do we know the court was wrong if that true up hasn't occurred? And how was it ever going to occur if there was no valuation?
Well, and again, I do believe there was an agreed value, and I will find that for the court. With respect to the error, though, what the court did was not make adjustments to the 50-50 split for the valuation. Now, we believe that was in the trial judge's mind, that the 51%, that controlling interest was, I believe the trial court used the word priceless. But what the trial court did was then used the prior summary judgment claims that Mrs. Yelvington raised in the October hearing, awarded her essentially, with the exception of one category, jet fuel, everything that she asked for, and tried to even it up that way. Your Honors, if there are any further questions, I'll be happy to address them. Otherwise, I'll reserve what I have remaining.
Thank you.
May it please the court. Your Honor, just to address your question about YAM, is what they call it, it was never an agreed valuation because the trust asset was split 50-50 for YAM. So there was no reason to value it because it just went like that. As to YJA, I want to reiterate, there was no agreed valuation for YJA. And I do want to return to Your Honor's question, because I'm not sure that I answered it correctly when you were talking about specificity. And I just heard a little bit of it. The trial court's reasons for granting these equitable adjustments in the November 7th order are articulated orally and then stated in the order. They have nothing to do with YJA. We can't impute that upon the trial court when he very clearly stated, I am giving this equitable adjustment for this reason and this reason. The Lear jet is a perfect example. In that circumstance, what the court heard testimony and saw documentary evidence of what was spent by Mr. Yelvington, and the claim was that it was done unilaterally, even though they were co-trustees. And the evidence supported Ms. Yelvington's claim that that money spent unilaterally did not return a profit for her. And so what the trial court said was, you're going to get half of that amount, that expense, returned back to your side of the ledger. It's a true up. It's not awarding her damages or awarding her additional funds. It's merely getting closer to 50-50. So I just want to make that point clear.
Counsel, what other litigation is pending? You said that one of you said there's other cases pending that potentially, I assume, could affect this case.
There are other cases pending. I don't believe any of them would affect this case. There's a pending case to dissolve what's called Yelvington Family Partnership. That's already been distributed. I don't think that would affect this. There is a case pending before the trial court for a records dispute relating to YJA and YAM. I believe that's it right now. And I also want to make clear that my client never claimed that one party should get a controlling interest in YJA. They did argue below that one party should get it or the other party should get it, but not a controlling interest. And Your Honor made the point, which I think is correct. The reason we see this is the only entity that's distributed 51% is because there was this component of YAM that you couldn't distribute 100% to one party because it was already owned by in some amount by the individuals. And I think that's what led the trial court down the path of, well, I can't just separate you guys completely, and that's where we had the novel concept of 51% to one party. I want to make the comment that the purpose of the October 18th hearing, which was the final hearing that led to the November 7th order, it was never set to value YJA. That's why neither side presented evidence or prepared any sort of pretrial statement relating to that. So that has yet to come.
What was the nature of the evidence in that? Was there testimony, documents? Would the parties testify?
That's correct. There was witnesses that testified regarding the damage to One Beach property, witnesses regarding the lost profits, the lost rent. There was testimony and documents about the planes, the Lear 45 and the Gulfstream. There was testimony and documents about Malibu Court as well. I'd like to address the summary judgment order. It is an interlocutory order, but secondly, I think the trial court was correct in stating even if I couldn't change that interlocutory order, I am still here to distribute 50-50, and that's exactly what the trial court looked at when it looked at each of these equitable adjustments, was just truing up what shouldn't be calculated on Ms. Yelvington's side of the ledger. That's all. Thank you.
Thank you, counsel.
May it please the court. I apologize, I was unable to find that valuation in the short amount of time, but my colleague is correct. It was divided 50-50, so ultimately at the end of the day, you don't need to make an adjustment in cash for the distribution of Yelvington Aviation Management because the trust's interest in that company did go 50-50 to Mr. and Mrs. Yelvington.
Even though that gave Mr. Yelvington a controlling interest in that entity?
Yes, Your Honor, because the trust's interest was just 50-50. Mr. Yelvington had 32%, Mrs. Yelvington, I believe, had 16%, and the trust had the rest. And so dividing up the trust's interest 50-50, just the natural result is that Mr. Yelvington ends up with a controlling interest in that company. So, Your Honors, with respect to the October 18th hearing, that hearing was supposed to cover reimbursements. It was for evidence that either of the parties had spent money on the maintenance and upkeep of trust assets. What happened at that hearing, though, was that Mrs. Yelvington attempted to present and tried to present evidence that Mr. Yelvington had breached his fiduciary duties. I won't get all the way back into it, but the Jets are the perfect example of the claims that were re-raised in that October 18th hearing, which was not what that hearing was supposed to be set for. There are multiple instances in the record where we can see that the idea was to what the trial court had asked for was evidence for those reimbursements. If someone spent money on a trust asset to maintain it while the litigation was pending, of course they should be reimbursed for that before the rest of the trust cash gets split 50-50. But that's not what happened.
Counsel, it sounds like both sides want us to send this back to the trial court for a do-over a number of things, and if history proves correct, we'll be seeing you in another couple of years at this court. I'd encourage some introspection. Hope always springs eternal, but I think that oftentimes you get advice in this legal world. Sometimes through mediation you can control your destiny, but it's up to y'all.
I understand. Thank you very much, Your Honor. If there are no further questions, I'm done. Thank you.
Thank you both. It was well presented by both sides. Given the fact this is our only case today on our OA calendar, we are officially in recess. Thank you.
Rise.